Fighting against injustice across Connecticut, Melissa in the Morning checks in with the Commission on Human Rights and Opportunities. Now on WICC 600 AM and 107.3 FM.
Hard to believe, but a lot of people going back to school today, this week, and then the rest going back after Labor Day weekend. And so let's do a back-to-school refresher with the Commission on Human Rights and Opportunities. Mike Roberts is here to talk about civil rights, not just for the students, but also for the adults, especially the staff. Hey, Mike, how are you?
I'm doing well, Melissa. How are you?
I'm doing fine. Thank you so much. And I'm glad we're going to be talking about this because, as I mentioned, it's very prevalent in our news here in Connecticut. So let's talk about some of the most common civil rights that the students have, that staff members have in the schools, even parents, I would say, as well, included in this conversation. What are things that people should know that maybe they don't realize are some of their rights as we head into a new school year?
Yeah, it's that time of year again, huh?
Right.
So for students in the public schools in Connecticut, they, by law, have the right to an equal opportunity to participate in the activities, the programs, the courses of study that are offered in schools and for which they're otherwise eligible. And they have that right free of discrimination on the basis of race, color, gender identity, religion, national origin, sexual orientation, or disability. So if they're otherwise eligible to participate based on age or academic factors, then they have the right to participate without discrimination on the basis of those protected classes.
So we're talking, so this has been a real controversial thing in sports at even the national level. But here in Connecticut, basically we're saying regardless of gender, they're able to participate.
Yes, correct. Yep. As the state of the law remains in Connecticut that while schools can have teams that are separated based on sex, that students have the right to participate on those teams in the manner that best fits with their gender identity.
So, and I just want to reiterate, so what we're saying is if we have what was formerly a male student saying that they identify as a female, by Connecticut law, they are able to, for public schools, they are able to compete on a female sports team.
Correct.
Interesting. That I do find, so by law, they're able to do that. Are the schools, so the schools do not have the right to say we don't agree with this?
Correct. I suppose that they could, if they were to raise some kind of a challenge, there's a very narrow grounds on which they could bring that challenge. Usually it's if under our statute there's an exception to our definition of gender identity if the identity is being asserted for what the statute calls an improper purpose. In all my years of doing this work, I have yet to see a situation in Connecticut where somebody was asserting their gender identity for an improper purpose. But yes, apart from that one very narrow, limited instance, if a student comes forward and they indicate what their gender identity is, then they have the right to participate in the manner that's consistent with that gender identity. Same with the facilities that the school has. So, for example, schools often have bathrooms and locker rooms separated on the basis of sex, but students have the right to use the bathroom or locker room that most aligns with their gender identity. Same in public spaces more generally as well. Many times if you go into a store, a restaurant, they have bathrooms that are separated on the basis of sex. Our statute, our public accommodation statute, has a provision that allows for separate bathrooms and locker rooms based on sex, but patrons, customers, employees have the right to use the bathroom, the restroom, the locker room that most aligns with their gender identity.
Wasn't there, though, Mike, wasn't there a case in Fairfield County where it was like a track and field or an indoor runner. I thought that there was a huge case that had to do with the CIAC allowing biological males to compete in girls or women's sports. I believe that case might have been dismissed, but I mean, didn't we just see this was like in the last, I want to say 5 or 6 years that there was an incident of this that happened in Connecticut?
Well, I don't know, but there have been trans athletes that have been competing in Connecticut, if that's what you mean. There was a case, and it remains ongoing, the Sewell case.
Yes.
That case remains ongoing. It was initially dismissed. It was filed January of 2024, and it's still ongoing. It was initially dismissed. It went up to the Second Circuit Court of Appeals, and then it came back down. And recently there was another hearing on another motion to dismiss, and so it was in the news again. But the state of the law, as of today, remains that, and going into this school year that's starting up now, that students have the right to compete in athletics and to use the facilities, the locker rooms, the bathrooms, to otherwise participate in a manner that is consistent with their gender identity.
And just to be clear, Mike Roberts with the Commission on Human Rights and Opportunities, when we say that they identify with a certain gender, we're not talking about people who are going through or have completed a sex change. This could very well be somebody who just says, I don't identify as a male. I identify as a female. So just by saying that, that's enough for them to be able to access female bathrooms or to be able to be on a female team.
Yeah, I mean, I'm not aware of anyone in Connecticut, anyone under the age of 18 who's in the public schools who will have undergone, a sort of sex reassignment operation, what has often been referred to as a sex change. Usually these are students who, have indicated what their identity is, that they were, perhaps assigned when they were born. The doctor or the medical professional put an M or an F typically. They were assigned a particular sex at birth, and that ultimately the child, the student, the teenager, the person has indicated that their identity does not match that sex assigned at birth. And so Connecticut law does not require any kind of particular medical treatment in order to have your gender identity recognized. One way that gender identity can be recognized is through a consistent and uniform assertion of the identity, which is often what for young people is looked for, and what young people are able to articulate, particularly if they're in a supportive environment. They can very, very ably give a consistent and uniform assertion of how they identify. And so once somebody indicates what their gender identity is, which usually is a part of a broader conversation, it usually is not just limited to the sports context. Usually it's a broader conversation involving the school, involving parents, guardians, involving other professionals. They have the right to be treated in accordance with their gender identity, regardless of whether that gender identity is different from or the same as that letter that was put on their birth certificate at birth.
Mike Roberts is here from the Commission on Human Rights and Opportunities. And Mike, forgive me, I'm sure you wanted to talk about a lot of different civil rights available to students and staff, adults, parents across Connecticut ahead of back to school. And I'd love to continue the conversation doing, maybe a part 2, since we are in back to school season this week, next week, and in the beginning of September. But this one that we started off with is certainly one that I know is a real talker, and I honestly have more questions about it now, having my own child who is now in the public school sector. He's going into first grade, and I do want to make something very clear. I so appreciate the partnership we have at the Commission on Human Rights and Opportunities. I am not affiliated with any political party. I am not attacking Mike. I just have questions as a parent. So this is me coming to you, Mike, as I'm going to take off my reporter hat for a quick second, if you don't mind, and put more of the parent hat on, if that's okay.
Sure.
So you were saying before that if a student is making consistent and uniform assertions that they identify with a certain gender. So if somebody was born a male, they have male anatomy, their birth certificate says male on it, but they get into middle and high school, let's just say, and they identify as a female. So if they consistently say, I identify as a female, they make that very clear. There are meetings, the parents are involved, teachers know about it. Okay, we're all on the same page. But essentially, we're going off the word of a preteen or a teenager saying, I identify as. That is enough for them to enter into female bathrooms or to be on female sports teams. Do you as an attorney believe that that's too open-ended, that we're just going off of the word of a preteen or a teenager and that's acceptable enough?
So two pieces to my answer to that. First, my job as an attorney for the commission is to apply the law, and the law says that that's enough. But just in my experience as an attorney, and my experience kind of in this area, I have seen that if it gets to the stage where there are these conversations happening, where the parents, the students, the teachers, the professionals are coming together to have a conversation about it, it's a really strong signal that the student is expressing their gender identity. That student has come forward in some way, depending on the age of the student, is making it known to the people in their life, the adults in their life, that this is how they identify. And the outcomes, if adults are not supportive of a student's identity, are really detrimental. We're talking about really severe and potentially the worst outcomes in terms of kids losing their lives if people are not being supportive of it. And so, there are ways to make space for a student to express their gender identity and for it to be really explored whether this is going to be the way that a student identifies in perpetuity, right? And that's why for young people, for minors, the kinds of, if it gets to the stage of medical intervention, usually what we're talking about are puberty blockers, things like that, that really just buy more time for decisions to be made within the young person's life before the more sort of irreversible or significant medical interventions are taking place. So if for that student, something like being able to use a bathroom that is consistent with their gender identity, being able to be treated by a name that is consistent with their gender identity, being able to participate in sports and other activities in a manner that's consistent with their gender identity. We're really talking about a way that potentially could be a life-saving measure to affirm a student's gender identity. And so a little bit of flexibility in that goes an immensely long way, when the opposite of that can also have a hugely detrimental effect.
But I also think, though, Mike, for those who identify with the gender that was their birth gender, I think we're doing a real detriment to them. I mean, I think there's a huge difference between respecting and supporting students who are identifying as something different. So if there is a young man who believes that he identifies as a female, I agree with you. No one should be bullying that student. Nobody should be judging that student. Nobody should be hurting them, attacking them, making them feel like they can't go through this process or that they're less than. I do not believe in that. I believe God created us all to love each other and in his own image. With that being said, though, I think that there has to be some kind of requirement beyond just saying, I think I'm a female, to be able to enter into female bathrooms. I mean, I have young nieces. I have my goddaughter who's entering school, and I would want to know that she is protected. I think it's not fair that we're willing to exaggerate the rights of one, if you want to call it, gender or class of students over others. I think it's putting children who do identify as female in a very uncomfortable position. Same thing with sports, to allow somebody who has the anatomy of a male, even if they feel that they are female, to allow them, when they have what a female's body doesn't have, to be able to compete with them. How is that fair to the student who still identifies as a female and is a female from their birth?
So there's a lot, within the realm of this issue that we're talking about. But Connecticut has had gender identity protections since 2011. So we're talking 13 years now that we've had gender identity protections enshrined in law in our state, and that's just codification. There were administrative decisions going back to the year 2000 in Connecticut that also recognized gender identity protections under our sex discrimination protection. So we're talking 2 decades, almost 25 years, a quarter century.
But I don't think we've had this gender identity. It feels like, at least from the media standpoint, I feel like gender identity and non-binary students and what pronouns are you using, that really, it felt like became very public in the last few years. So while we had the protections, it doesn't feel like this was really that big of a deal.
Well, I think trans individuals and gender non-binary individuals, gender non-conforming individuals have always existed. The language may have developed, and the atmosphere of acceptance and support may have advanced, but they've always existed. And I think one reason why we're seeing it more and more in the public sphere is that there has been, in part, a concerted effort to highlight this as an issue. There has been a concerted effort to bring legal cases to challenge gender identity protections. I think it's not a coincidence, far from it, that once marriage equality was obtained, that the Supreme Court, the U.S. Supreme Court, recognized its constitutional protection, that there was a shift into another sort of wedge issue, which has continued to be brought up in the public sphere. And so I think, but just because it's now been highlighted in that way does not mean that it's a new issue. Certainly the way that we, talk about sexual orientation today in 2024 is very different than it was discussed, even 10 years ago, 20 years ago. The words that we have for it now, gay, lesbian, even the term homosexual, only date back to the end of the 1800s. But that doesn't mean that that's when that concept was invented. LGBT plus people have always existed. So now that we have sort of a conversation now that we're able to have with respect to pronouns, with respect to how we can best support trans students, and we're able to have that conversation now, or just because it's appearing in kind of news arguments or legal cases does not mean that it's sort of a new development. The protections have existed for about 25 years. I'm not aware of a single instance in Connecticut where somebody has taken advantage of those protections in order to engage in misconduct in a bathroom, locker room, or restroom. Certainly, if anyone, regardless of their identity, regardless of the sex that they were assigned by at birth, is engaging in, is engaging in misconduct in one of those areas, that's impermissible. But I'm not aware of anyone using the gender identity protections that we have on the books in order to do that. The most, I think, significant case I heard in the last few years was actually of a non-binary student, Knox Benedict, in the Midwest, who was engaged, who was, attempting to use a bathroom that was consistent with their gender identity, and was assaulted, and then ultimately died. So again, I haven't heard of anyone using those protections in a way that would perpetuate misconduct or to take advantage of that. What I have heard repeatedly over the course of time is when folks aren't able to access the bathrooms and locker rooms that are consistent with their gender identity, or even if they can use the bathrooms that are consistent with their gender identity, that there are still these risks that are involved that for them, for that student, for the trans or non-binary student, and that the risks associated with not allowing folks to use the bathrooms, facilities, engage in the activities, and otherwise live their lives in accordance with their gender identity are detrimental, and that is verifiable and proven.
Mike Romberts with the Commission on Human Rights and Opportunities, thank you so much for this insight, and I'm sure we'll be talking about more of this, especially as we head into the new school year and some